Right now, they'll want to welcome to the program Dr. A.W.R. Hawkins, who has a new piece out at the Daily Caller all about one of President Barack Obama's judicial appointees and the outright hostility displayed towards your right to keep and bear arms. Dr. Hawkins, good evening to you, sir.
Hey, Cam, good evening. Good to be with you.
It's great talking to you again. All right, so your piece of the Daily Caller, Obama judicial appointee says we have the right to keep arms, but not to bear them. And you talk about Wayne LaPierre's speech at CPAC, where he predicted that if President Obama wins a second term, it's basically an all-out attack on the right to keep and bear arms.
That's exactly right. And the judge in view here is Sue Myerscough, and she did say that the Second Amendment Foundation had filed a suit, and I'm not certain. The NRA may have joined that suit late. They may not have joined it. I'm not certain. I know the Second Amendment Foundation filed it, and it was to overturn Illinois' continued refusal to allow people to get concealed carry permits or to have some type of concealed carry law. And she ruled, as you said, that while the Second Amendment protects our right to keep arms, that to this point the Supreme Court hasn't recognized a right to bear arms. And there are so many problems with that decision that we don't even have time to get into all of them.
We have seen a pattern emerge from the judges that President Obama has either appointed or nominated to some of these courts, Dr. Hawkins, whether it's Supreme Court justices like Elena Kagan and Sonia Sotomayor, or this Judge Myerscough there in Chicago. The common denominator is that these are judicial appointees who really believe that the Second Amendment is a dead letter. And in the case of Judge Myerscough, clearly trying to limit the Second Amendment as much as possible, given the Heller and McDonald rulings. But again, we shouldn't be surprised by this. This is, would we really expect President Obama to nominate judges and justices who believe in the Second Amendment, who look at the Bill of Rights and says, well, the right to keep and bear arms shall not be infringed, must mean the right of the people to keep and bear arms shall not be infringed?
Oh, you're exactly right. And that's why Mr. LaPierre, who I have a ton of respect for, he was right. This is what we're going to see if Obama wins 4 more years. And as you say, this should not surprise us. And if we go back to Obama as a state senator in Illinois, he supported legislation that banned the use of handguns for defensive purposes. You could not defend yourself with a weapon. He supported one weapon a month purchase limitations. He supported so many asinine articles like that, and at the same time would say, but I support the Second Amendment. He supported the Keller gun ban. Not Keller. He supported the gun ban in Washington, D.C. During the Keller case, yet he said I was for the Second Amendment. He supported the Chicago gun ban, yet he continued to say I support the Second Amendment. And so we've got to learn, these people can say whatever they want. They hate the Second Amendment. They hate our right to defend ourselves, and they want to do away with it.
We've seen, not just in Chicago but around the country, other judges that have taken this view. And I remember talking about a New Jersey decision actually a couple of weeks ago. And it seems like there's a great deal of dishonesty, I think, in some of these judicial rulings where the judges will they'll say that they're relying on Heller or McDonald, and they'll say, well, the Supreme Court has not said anything at all about a right to keep and bear arms and self-defense outside of the home, therefore one must not exist. That wasn't the issue in Heller, and that wasn't the issue in McDonald. At issue in both of those cases was the right to keep your firearm, including a handgun, in your home for self-defense. But we talked with Steve Hallbrook, who's a Second Amendment attorney and scholar, representing the representing the NRA in a lawsuit challenging the post-Heller gun laws in the District of Columbia. And he pointed out that in the Heller decision, while the court made a note about concealed carry not being allowed everywhere, I think they used the sensitive places language. They clearly did not say that concealed carry or the carrying of firearms was outside of the purview of the Second Amendment. In fact, by talking about some of the places where guns should not presumptively be allowed, they indicated that there were a lot of places where concealed carry presumptively should be allowed.
Well, I I agree 100%, and I have the utmost respect for Holbrook and concur 100% with what he said there as relayed by you. I would add to that that in McDonald versus Chicago, in the second case, when Sam Alito wrote the majority opinion for the court, Sam Alito said, as I cite in my article today, he said that self-defense is a basic right and is the central component of the Second Amendment. Now, if you just think about that, there's no way that a court believes we're only allowed to defend ourselves within our homes. Is myself only worth defense in my bedroom or in my den? Is myself not also worth defense in Walmart or in Pizza Hut, so on and so forth?
Right.
And I believe it's evident that the court believes I don't just have a right to keep and bear arms in my bedroom. I have a right to keep and bear arms, period, because that's the right that God gave me.
Talking with Dr. A.W.R. Hawkins from BigGovernment.com. His piece in the Daily Caller on President Obama's judicial appointee was out today. You write, Dr. Hawkins, you say if Obama manages to get reelected, be ready to see more of these Myers-Cough-like decisions come down the pike, decisions where judges give lip service to the Second Amendment on the one hand, while stealthily undercutting it on the other. You know, it is rare these days to find a politician or even a gun control advocate who will admit to wanting to ban firearms, even though just a few years ago that was, the standard statement for these gun control advocates. Heller and McDonald have made it much more difficult for the anti-gunners to be honest and upfront with what they want to do. So now they're using a lot of these weasel words like, we support the Second Amendment, Dr. Hawkins, just not the right to own a gun that's capable of, holding more than 5 rounds, or a gun that is capable of being concealed in somebody's pocket or in a holster and covered with a jacket. You get that statement of we're not after your guns, and then you get the laundry list of gun control regulations that they want to put in place regardless.
Yeah, you're exactly right, because they are after him. And I'll tell you, a thing in Myers-Cough's decision that everyone needs to pay attention to, that we spoke of when we first began here, Tim, when she says, listen, we have the right to keep and bear arms, but the Supreme Court, she said we have the right to keep arms, but the Supreme Court has not recognized the right to bear them in public. We have to understand, she's trying to split the atom there. She's trying to say we have a God-given right to keep arms, but the second part of that right, the bearing and the using of those arms, that is up to a court to decide. That is the mistake that we cannot make. We cannot give an inch on this. God gave us the right to self-defense. Sam Alito was stressing that. And Sam Alito even says, to anyone who wants to read the decision in McDonald v. Chicago, Sam Alito said the best weapon for self-defense is a handgun. All of these things are contained in the decision that Myers-Cough must not have read. And we have to understand, regardless of what she or any other court says, God gave us a life that is so valuable, we have an inalienable right to defend it. And the handgun is the best weapon with which to do that.
Dr. Hawkins, as always, sir, it is great getting a chance to catch up with you, and I hope that everybody who's listening tonight will head to dailycaller.com, check out your piece about this anti-gun judge, and really, again, how important it is looking forward into the next 4 years that we keep in mind the damage that can be done to our constitutional rights through additional judicial appointees like this one.
That's right. Thank you, Cam. God bless.
All right, you too, sir. We'll be talking with you again very soon. Dr. A.W.R. Hawkins joining us tonight here on Cam and Company.